I don't know how this stuff works. I'm new to this.
All right, this is case number 02-561-9901. The people of the state of Michigan versus Carnell McCrary. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pre-trial conference. And Mr. McCrary, your name?
Carnell Michael McCrary, ill, all lowercase, not the all caps.
All right, guys. Today, we are going to witness the continuation of a legal train wreck already set in motion. From the very start, the tone is clear. This defendant is walking into the courtroom armed with internet theories, not legal knowledge. The commentator sets the stage by reminding us this is Judge Bryant's courtroom, one known for structure, discipline, and zero tolerance for theatrics. The missing original recording adds irony, but thanks to a riposte, we're about to watch a sovereign citizen step directly into a system he clearly doesn't respect or understand. This introduction frames the conflict perfectly: rigid courtroom reality versus fantasy law beliefs, and there's no question which one is about to win.
Pre-trial conference, and Mr. McCrary, I understand that you are representing yourself, so how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Hey, Mr. McCrary, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court matter?
As the hearing begins, confusion immediately takes center stage. The defendant openly admits he doesn't know how this stuff works, which is astonishing given he chose to represent himself. Instead of humility, he doubles down with the all-lowercase name routine, signaling classic sovereign citizen ideology. This moment is crucial because it highlights the disconnect between legal procedure and personal belief. Courts operate on rules, not symbolism. Judge Bryant allows him to speak, but she doesn't indulge nonsense. This exchange quietly foreshadows what's coming: a defendant mistaking ignorance for strategy, and a judge prepared to shut that down efficiently.
I want to know, as it relates to this pre-trial conference where you've indicated that you want to represent yourself, it is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pre-trial conference. As it relates to the pre-trial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court. You're
going to be restrained every time you go off course. So, understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McCrary, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias.
Here's where the mask slips fully. The defendant insists his name format matters legally, while the judge keeps things grounded in reality. The commentator's sarcastic aside emphasizes just how detached these beliefs are from actual law. This isn't clever resistance, it's self-sabotage. The court isn't offended, it's unimpressed. This segment shows the danger of mistaking fringe legal myths for legitimate defenses. The judge remains calm, but the patience clock is clearly ticking. The courtroom is not a debate club, and symbolic arguments don't replace lawful procedure.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCrary, and ask him how does he wish to proceed with the hearing for Mr. McCrary.
Yes, Your Honor. Violating code of judicial conduct, Judge. And I haven't been
doing this for 16 years. I know what I'm supposed to do. So, Mr. McCrary, I'm addressing your request on the recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay. The
Thank you.
rule man you sent me
Okay, thank
beforehand.
you, Mr. McQuarrie. Thank you, Mr. McQuarrie.
Yes, ma'am.
Your Honor,
Yes, sir.
they indicated that he would need to file a motion for recusal before you. And if you deny that, it then goes to the Chief Judge.
He already
Well,
did. I accepted
well,
his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion.
correct.
He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So, Mr. McQuarrie, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay.
Who do my call? The clerk? What is not?
Sir, if you just, I promise you, I've been on the bench for 16 years. And I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your current contact information so that the chief judge's office can contact you with respect to your hearing on my denial of your request.
When asked how he wants to proceed, the defendant shifts into grievance mode, claiming disrespect and First Amendment violations. This is a classic diversion tactic, turning procedural questions into emotional accusations. Judge Bryant's response is surgical. Feelings are irrelevant. Process is everything. This moment reinforces a hard truth many pro se defendants miss. The court's role isn't validation. It's resolution. The commentary underscores that emotional narratives don't move cases forward. The law doesn't pause for personal offense, and trying to force it to do so only weakens your position.
Nothing personal with you. It's just that
Mr. McQuarrie, I don't take things personally. Ms. McQuarrie, let me say something to you. So since we're talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And
correct.
Maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the matter.
Now the judge draws a firm line. She explains exactly what this hearing is and isn't, making it clear motions aren't on the table today. The defendant is warned, politely but firmly, that self-representation requires understanding court rules. This segment is a masterclass in judicial control. The judge isn't hostile. She's structured. The commentary points out that courtroom authority doesn't need to raise its voice. It simply states expectations and enforces them. This is where the defendant could recalibrate, but instead, he escalates.
I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about. I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference, for Mr. McQuarrie is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right,
May
then,
I
sir, you're all set.
Predictably, the defendant cries restraint the moment he's redirected. Judge Bryant responds with clarity. Restraint isn't punishment, it's procedure. Everyone is bound by it. Then comes the big move, the motion to disqualify the judge for bias. The commentary nails the irony. Claiming bias because a judge enforces rules is like accusing a referee of cheating for calling fouls. This is a strategic misfire born from misunderstanding judicial standards. Bias requires evidence, not discomfort, and this motion is dead on arrival.